Good morning. My name is Captain Brandon Carpin. I'm the Attorney Advisor to the Adjutant General and the Trial Counsel for the 116th CBCT. Today I'm going to be briefing you on the Idaho Code of Military Justice. This serves as your annual legal brief. Today we're going to be discussing a comparison between military and civilian justice systems, ICMJ jurisdiction, various administrative actions, non-judicial punishment, as well as court-martials briefly. Military justice system has been around for forever. From ancient Rome to current day. Back in the olden times, it was a less formal. To current day is very codified rules that we have. The point, however, has always been the same, and that is to maintain a disciplined fighting force. Previously, punishment and penalties were severe. For example, a commander in the Roman army was able to order summary execution as of right, as recently as General George Washington urging the Continental Congress to raise the limit of flogging from 39 to 100 lashes. Following World War I, concerns regarding the harshness of punishment and lack of process began to form the current landscape, and in 1950, the ICMJ was enacted. Five years ago, the state of Idaho adopted the Idaho Code of Military Justice that reflects or mirrors the Uniform Code of Military Justice. However, as from the beginning, the purpose of the Code of Military Justice is the same, and that is to help maintain good order and discipline of our fighting forces. What is the difference between the military and civilian justice system? There are a number of differences. There are also a number of similarities. In the military as well as in the civilian system, you have the right to counsel. However, in the military, you have an unbridled right to counsel in almost all adversarial cases. In the civilian system, you must be indigent and prove that you are. In the civilian system, all criminal actions attach a jury system. In the military system, a panel of that nature is not always required. In the civilian system, military or justice actions are driven by a prosecutor. In the military, they are driven by a commander. A commander initiates investigations. They determine whether or not charges are going to be preferred or brought against you, and they take action after sentence. So what are the sources of military justice? Of course, the United States Constitution, the Uniform Code of Military Justice, the Idaho Code of Military Justice, as well as IMD 22, which is the TAGS policy, also confusingly named the Idaho Code of Military Justice. Manual for Courts Martial is a reference, administrative reference, as well as any local Army, Air, or military division regulations. What is the jurisdiction of the Idaho Code of Military Justice, or the military division? Well, the military division, or your commander, has jurisdiction for your misconduct or alleged misconduct anytime you are on a military status. That is, when you are here for your annual training or an IDT, or you are deployed for state active duty. The ICMJ always has jurisdiction. Additionally, the ICMJ applies to members 24 hours a day, 7 days a week, so long as there is a military nexus. What is that military nexus? If I, as the prosecutor in that case, can prove that your crime or misconduct has a bearing on your military membership, and that it affects the morale, for example, there will be a military nexus, and you can be prosecuted for military misconduct. For you M-Day folks out there, that means even in your civilian capacity, if you commit a crime, you can be prosecuted under the ICMJ. Of course, the ICMJ only applies when you are a Title 32 soldier. When you are placed on active duty, you are a Title 10 soldier, and the Uniform Code of Military Justice applies. If you are accused of a crime, you have rights. These are called Article 31 rights under the ICMJ or UCMJ. Essentially, these are Miranda rights. Anyone who has seen any kind of crime show, those usually lead with the right to remain silent. Those rights are the same here. They are reflected, however, under Article 31. Okay, so we're going to talk a little bit about specific crimes under the ICMJ. Of course, we have all of the 9 non-criminal military-specific crimes. For example, rape, homicide, larceny, robbery, sexual assault, anything like that. Additionally, we have a slew of military-specific crimes. For example, disrespect of a superior officer, disobedience, AWOL, conduct unbecoming, or conduct prejudicial to good order and discipline, or missing movement. Anytime you don't show up to drill, that is a crime. Anytime you backtalk a superior officer, that is also a crime. These folks are criminals under federal law, and I don't think they are subject to the ICMJ or UCMJ because they don't appear to be real soldiers. Okay, so I'm going to go through all of these slides. You can look at them at your leisure, or if you want to refer to the manual for court-martial, you can read through these, or if you want to refer to the ICMJ specifically. All of these subsequent slides contain pretty much every article that you can be punished for. I'm going to highlight the most relevant ones. If you have any other questions, my point of contact was on this first slide. You can rewind the video and contact me then. However, I would like to highlight a few things. First of all, Article 2, ICMJ applies at all times. Article 3, you can be, if you leave military service and you think that you have escaped ICMJ jurisdiction, think again. We can bring you back in if you are out fraudulently, and you can be retried under the ICMJ. Article 25, if you are subject to a courts-martial, you will be judged by a senior member. Article 27, that is your right to counsel. In the Army, we call that Trial Defense Service, or TDS. Article 78, if you know of an offense or if you know of a crime and you help cover it up or you don't report it, you are guilty of being an accessory after the fact. Additionally, under Article 83, lying to get out of service is a crime under the ICMJ. So malingering for a PT test in order to get out of the military is a violation of the Code of Military Justice. Article 88, contempt towards officials. That includes Congress, the President, the Secretary of Defense, the Secretary of the Military Division, and the Secretary of Homeland Security, as well as the Governor in the state of Idaho. We are in very hyper-political times. You might think that it's therefore a free-for-all in open discussion. That First Amendment right that you have does not go away. However, be careful, because the language that you use when discussing government officials may be criminal in nature. Any contemptuous words towards those officials are a crime and will be prosecuted. Likewise, when you consider Article 89 and 90, just be respectful to whoever you encounter, and make sure to just do your job. Don't be Cartman. Article 92, This is probably the biggest ICMJ article that we prosecute under. This includes a failure to obey a general order, for example, the IDNG alcohol policy, or the DoD GSA vehicle regulation, or travel card regulations. It also includes a failure to obey a direct order from a superior officer. Article 107 is a false official statement. When you sign a document with the intent to deceive, these are beyond just sworn documents, any kind of recruiting document, medical evaluations, financial documents. If you provide a false document to the military, that is a false official statement and is a crime. Article 112. Unfortunately, we've had a slew of Article 112 prosecutions that we have committed to recently. Pay close attention to this during a fun day event or when you are on duty. If you are intoxicated while you're on duty or while you're under orders, this is a crime. Additionally, Article 112A, 112 Alpha, this is your hot UA. I'll also pay particular attention to Article 114. Dueling is now out. Do not be Hamilton or Burr. Okay, drug offenses, as we discussed, are crimes under 112A. This does not just include ingestion of drug. It also includes possession of drugs, distribution of drugs, the manufacture, import, or introduction of drugs onto a military installation. Drugs are bad. Article 133 and 134 are general conduct articles. They relate to actions that are unbecoming or prejudicial to good order and discipline. These are behavior crimes. So what does it all mean? What does the prejudicial to good order and discipline mean? Well, first of all, it's kind of a 2.5-part test. Number one, you have to take an action or a failure to act. Number two, you have to have an impact on the unit or impact on the Army or the military division as a whole. A crime such as animal abuse, bigamy, bouncing checks, failing to pay a debt, viewing child porn, having extramarital sexual contact, fraternizing with lower enlisted, making disloyal statements, or intentionally avoiding service are defined as prejudicial actions. There are also novel offenses where you can just choose your own adventure. These are often state or federal crimes, but may not be. Producing pornography of your own volition may be a crime under the ICMJ. Then the second part, which we've seen, is prejudicial to good order or discipline, or of a nature to bring discredit upon the armed services. The way that you can evaluate this is, would a reasonable person believe that this harms the reputation of the military if that action were discovered by the public, i.e. the offense will speak for itself. There are a number of key personnel in the military justice system. As we discussed, it is a commander-driven system. The commander is the instigator of an investigation. They discover who has done what. Additionally, that commander is the same individual at some level who decides whether or not a crime or a case will be prosecuted at any level. There's the Office of the Staff Judge Advocate. Here in the military division, that's Major Stephen Stokes. He advises the commander at the higher levels. And then the trial counsel, which is me. I serve essentially as a prosecutor in military crimes. TDS counsel has been assigned in any case. There's also a right to a special victims counsel in some cases, in sexual assault cases. Of course, a military judge or a military magistrate or a judge that has been validated under Idaho law will be available, potentially depending on the type of courts-martial that we're dealing with. There may be a panel, and the most likely person that you're going to encounter in any kind of military justice action would be a paralegal specialist. Every battalion has one. As I indicated, the commander's responsibilities are to ensure that the military division maintains its maximum lethality. That is the function of the base function of our office as a whole. In order to maintain maximum lethality, a commander needs to have good order and discipline of its fighting force, of his or her fighting force. In order to maintain that good order and discipline, they're required to investigate any offense, find out what happened, and enforce the law, as well as protect soldiers' rights and soldiers' livelihoods. Finally, they need to determine the disposition of cases, whether or not punishment is appropriate and what level of punishment should be taken. When a commander discovers there's an offense, it's been substantiated by an investigation, he has a few options. He can investigate, take no action after the investigation is complete. There are a number of administrative actions, that is your counseling, your on-the-spot correction, all the way up to a GOMAR or administrative separation, or on the officer side, withdrawal of federal recognition, which is a woofer board. Those administrative actions are not punitive in that they're not considered a criminal action. They're administrative in nature. Even though they feel like punishment, they're not. In more serious offenses, the commander has the available tool of non-judicial punishment, or an Article 15. That is a very informal punitive action made for lesser crimes, and they're aimed at correcting minor misconduct with the aim of rehabilitation. For more serious crimes, the commander has the option to refer a crime for court-martial. Additionally, when a crime has been referred for an Article 15, a soldier has the ability to turn down that Article 15 and demand a trial by courts-martial. If you are subject to an Article 15, which hopefully you never will be, we will describe that process in much more detail. If you're a visual person, here's a flow chart describing pretty much anything that could and would happen in the event that there was some misconduct. Here's what we discussed as far as the administrative actions that are available to a commander in various ascending gravity, beginning with a counseling form or corrective training, all the way up to administrative reductions and separations. These are the 4 punitive actions that can be taken against you. I'll broadly describe them as 2. One is non-judicial punishment, and the last 3 are courts-martial. If you're an E6 or below, you're headed to a summary courts-martial, which is judged by a single summary courts-martial officer. If you are an officer or a warrant officer or an E7 or above, you are headed to a special courts-martial. Only the TAG has the availability to convene a general courts-martial, and depending on the level of misconduct, more than likely that would be prosecuted by local law enforcement. Another way to look at these levels of punitive action would be to compare them to civilian court. Non-judicial punishment would be a parking citation. Summary courts-martial would be traffic court. Special courts-martial would be misdemeanor court, and general courts-martial would be felony court. As I discussed earlier, non-judicial punishment is a disciplinary measure more serious than administrative corrective measures, but less serious than a trial by court-martial. Ordinarily, they are appropriate when administrative corrective measures are inadequate due to the nature of the offense or the record of the service member. An essential and prompt means of maintaining good order and discipline. An Article 15 promotes positive behavior and changes in service members without the stigma of a court-martial conviction. An NJP is always considered on an individual basis. There is no sweeping rule as to what type of misconduct or crime is appropriate for an NJP. Commanders exercise discretion in evaluating the case as to whether an NJP is appropriate and the nature and the amount of punishment that are available to them. One important note for those commanders and higher level officers out there: a superior may not direct that a subordinate commander impose an NJP or direct that a subordinate should dispose of an NJP in a certain way. Of course, that is unlawful command influence. Punishments available under an NJP are listed here. The big three are confinement, forfeiture of pay, and reduction in rank. For a field grade officer that is imposing non-judicial punishment, that is generally a reduction of rank of 2 stripes. For a company grade officer, that is generally a reduction in rank of 1 stripe. Unless a service member is attached to a ship under Article 15, so never, under Article 15, ICMJ may not be imposed on any member before the imposition of punishment. They may demand a trial by court-martial in lieu of punishment. The officer who imposed the punishment may at any time suspend, set aside, mitigate, or remit any part or amount of the punishment and restore all rights, privileges, and property affected. So if a commander imposes a 2-stripe reduction on one of their soldiers in their formation, at any given time, that commander may set aside, essentially pardon that same punishment. NJP procedure is fairly simple. It's the same under the Army as well as the Air Force. It starts with what we call a first read or a notification. That is, the service member who's been accused of misconduct or crime is brought in by their commander, read read the pertinent article that they've been charged with, the specification as we call it, and given information as to their rights to deliver any matters in mitigation or defense, as well as their right to consult with trial defense service. They then have 48 hours, or on the National Guard side, that is usually 1 drill period, to consider whether or not they want to consent with proceeding under the NJP process. At that point, they'll come in for what we call the second read. That is a phase where the member will be able to elect to proceed with punishment under the NJP process, or they will be able to elect to proceed to trial by court-martial. The purpose in, anecdotally, the drawback in proceeding to a trial by court-martial is that the punishment available that you're susceptible to is far higher. Briefly discuss courts-martial. Trial by summary court, a simplified procedure for the resolution of charges involving minor incidents of misconduct, where a soldier below the rank of E6 or at the rank of E6 has rejected an NJP or other minor misconduct. The summary courts-martial consists of 1 officer. That officer serves as the judge, the jury, the prosecutor, and defense counsel. A typical summary courts-martial would be the accused, the summary court-martial officer, and any witness brought in to testify. Once that evidence is produced to the summary court-martial officer, that summary court-martial officer may impose punishment. That punishment is similar to that of available under a NJP. However, it also includes hard labor, more significant forfeiture, and confinement. A special court-martial is kind of the intermediate one that will proceed with a panel of no less than 3 members. 2 must be officers, at least. Regardless of the offense involved, a sentence by a special court-martial is limited to no more than 1 year confinement, a forfeiture of pay, and bad conduct discharge. In all likelihood, confinement under the ICMJ would be housed at the Ada County Jail. Summary courts-martial convening authority, the authority who can order that a summary courts-martial take place, is the 05, 06 level commanders. As I mentioned, the soldier has no right to representation at a summary courts-martial. Any 7 or above can refuse the courts-martial, and I already discussed the procedure and jurisdiction. Again, special courts-martial put in bullet points. The convening authority at our level in the National Guard is probably going to be a brigade commander or the ATAG. A general courts-martial is reserved to the TAG as the general courts-martial convening authority. You have a right to representation, similar to that in the special courts-martial. You'll have an officer enlisted panel of no less than 5 members and an Article 32 hearing, which is referred to as a preliminary hearing to ensure that you have been charged adequately and there is probable cause to believe that you committed that crime. Under the ICMJ, the maximum allowed punishment is 10 years incarceration. We have yet to charge anyone under a general courts-martial. We don't have a contract with the penitentiary, so it may be likely that you will be incarcerated at the Ada County Jail for a period of 10 years if you commit a crime that is chargeable under a general courts-martial. Additionally, under a special as well as a general, you can be reduced to an E1 and discharged under a bad conduct or dishonorable discharge. For an officer, that would be a dismissal. At this point, I believe that we have covered extraordinarily quickly the Idaho Code of Military Justice and the justice system. If you have any questions, if you are a commander who is considering punitive or adverse administrative action, please consult with your servicing judge advocate. If you are a soldier who is considering misconduct, please think again. You know that you can be punished under the ICMJ for a number of different crimes. At that point, now that you have been informed, you can handle the truth. Thank you.